Hello, everyone, and welcome to our presentation, part one, regarding the ethics of attorney fees. By way of introduction, I am Patrick John McKinley. I am your friendly neighborhood bar grievance defense attorney. And what I mean by that is that I'm proud to defend my fellow lawyers, fellow members of the Florida Bar and District of Columbia Bar against bar grievances, ethics complaints, and ethics investigations. It's a major part of my practice, and I enjoy doing it very much. Now, today's presentation is about ethics and attorney fees. And the name of the presentation is a bit redundant, is it not? Because the issue of attorney fees is always an issue of ethics. Ethics and attorney fees go hand in hand because an attorney fee issue is an ethics issue. Anyone will tell you that on a proper analysis. So in order for any lawyer to properly price her or his services and therefore charge a fair and acceptable and permissible fee, that is a question of ethics. So I'm happy to guide you through the rules that apply. Now, of course, I'll be looking somewhat at the model rules because they are the basis of almost all state rules. I'll be looking with particular emphasis on the rules regulating the Florida Bar. And in this part one of our presentation, after we go over a few initial issues, we'll be focusing first upon contingency fees. Now, those of you who have charged a contingency fee or will in the future, of course, are particularly interested in this unit. Those of you defending against a claim of contingency fees should also be interested. But I dare to say that even if you never intend to charge a contingency fee, these rules still apply to you and you should still be familiar with them. So I hope that they are of great assistance to you. Of course, if you're planning on passing a bar exam or taking the MPRE, Model Rules of Professional Conduct, this knowledge will be critical. So I dare say that all within the sound of my voice can benefit from this topic. Hopefully, you'll benefit from my presentation of the topic. So now let's begin, shall we? And take a look at the ethics of attorney fees. We begin at the beginning. We state the lay of the land. We give you some insight as to exactly what we'll be covering both in this first unit and in the remaining units of our ethics and attorney fees presentation. Some common issues that arise when it comes to attorney fees are the following. First, every attorney fee in every jurisdiction is subject to a reasonableness requirement. Now, in some jurisdictions, I think, for example, of Kansas, they are wise enough to include in their rules of professionalism, in the comments, I believe, in Kansas, the fact that reasonable is a vague standard. Indeed, the commentary in Kansas goes so far as to state that reasonableness by itself will not be a basis for discipline of an attorney. Not every rule says that in the comments, but probably should, because as any prosecutor or bar counsel would probably be honest to admit, it's a very difficult thing to draw the line between a reasonable fee and an unreasonable fee. This is true even in the world of contingency fees, where contingency fees are subject to such voluminous rules and regulations. It almost becomes a defense to reasonableness to say that the contingency fee met the voluminous rules and regulations under that particular bar. But of course, that would be a wrong statement to say. We need to do more than just meet the bare minimum, even if it's a contingent fee. Still, we must examine whether that fee is reasonable. And as our presentation continues, I will help to illustrate where the boundaries may be when it comes to the reasonableness of a fee, be it a contingent one or not a contingent one. Keep in mind that the rule for reasonableness is not a minimum. Likewise, it is not a maximum. Now, just like any other profession, it would be a violation to fix fees. Price fixing, regardless of the profession, is illegal under federal law, if not state law, certainly federal. So wherever you are in our 50 states, District of Columbia, and many territories, don't interpret your rules of professionalism to be some sort of way around federal law when it comes to price fixing. No, no, no. We can't properly interpret the rules of professionalism to violate a federal law, not even a price fixing law. So yes, there sometimes are stated in rules, and we're going to go over some in greater detail, that set a maximum fee. But even then, there has to be those instances, albeit they can be rare, there has to be those instances where even the maximum fee can be reviewed. Likewise, fees can't be stated in rules of professionalism as a minimum, because to do either, set a maximum or set a minimum, either one would be a violation of fee fixing, price fixing. Stumbled over my words. But you know what I'm saying when I say to you, we can't get together and fix prices, not even via a rule of professionalism. Another common issue we see in attorney fees is that there are special instances that invoke specific rules to prevent abuse. You see this in the model rules, and you see it implemented in the rules of many states. For example, under the model rules and under the rules regulated in the Florida bar and under the DC rules of professional conduct and in the vast majority of states, contingency fees must be in writing. There must be a writing confirming the agreement as to what the contingency is and how much the contingent fee is going to be and how that amount is calculated. All that has to be in writing. The question then is, what if it's not a contingent fee? Must it be in writing? And the general rule is no. The contingency fee must be in writing. Other fees, if you dare do it, can be on a handshake, can be via an email or letter, can be via a verbal contract. This is true under the model rules, the DC rules of professional conduct, and the rules regulating the Florida bar. It is the majority rule throughout our nation. Fees divided between lawyers who are not in the same firm is a common scenario that is regulated by rules of professionalism. Under the model rules of professional conduct, if the fees are to be divided between lawyers who are not in the same firm, that fee agreement has to be in writing, and it has to be disclosed to the client with the client's consent. So that's the model rule and the majority rule. If you're splitting fees and they're not in your firm, you've got to have it in writing, and the client needs informed consent. Another issue that arises, a special instance that invokes specific rules to prevent abuse, is that certain client types in certain jurisdictions must sign certain written notices. I state that very broadly here at the beginning, but as we explore specifically the rules regulating the Florida bar, you're going to hear about several different writings and notices, what they must contain, who must sign them, and how long they have to be retained and by who they must be kept and retained. Check the specifics of your jurisdiction. The model rules will remind you that certain client types in certain jurisdictions must sign certain notices. Another issue that will come up as we explore the ethics of attorney fees is that contingency fees are not allowed in certain law types. There are certain areas of the law, most commonly criminal law, where a contingency for a criminal defense attorney is simply not permitted. Under the model rules and everywhere, the criminal defense attorney cannot do the criminal defense work on a contingent basis. But there are other areas in the model rules and in state rules where that's true too, where you can't work on a contingency. Very common, is not allowed in a lot of types of family law. This varies by jurisdiction. But if you're taking something like the MPRE, watch out for the contingent family law issue. They like to test on that. If you're practicing in the state of Florida, as I am, you'll see with great specificity later in this presentation what types of family law issues can be pursued on a contingency and what types are not allowed to be pursued on a contingency in a family law case under the rules regulating the Florida bar. Another issue to watch out for in the ethics of attorney fees is that disputed funds must remain in trust accounts until they are adjudicated. Remember that rule about how if the client doesn't agree as to who gets what on those fees, it is incumbent upon the lawyer not to make the decision herself or himself, but instead it's incumbent upon the lawyer to get that issue adjudicated. Another and final part of our blueprint of what we're going to talk about in these units is that literary rights may not be negotiated pre-termination. More details to follow. So with that lay of the land, with that groundwork, if you will, of common issues to watch out for as you practice and as you study the ethics of attorney fees, let's take a closer look at a specific instance of a type of attorney fee which is heavily regulated, both under the model rules of professional conduct and under the various jurisdictions throughout the United States. And that's the type of attorney fee that is contingent. A contingent fee, working on a contingency. We're all familiar with it, even if you're not a lawyer. You're surely seen lawyer advertising that talks about we don't get paid unless we win, or that talks about no fee if no recovery, or sometimes no fee and no cost if no recovery. These are examples of a contingent attorney fee. But for a more specific example, let me turn to Louisiana. Let me turn to 2006. And why does a member of the Florida bar and a DC bar like myself leave Florida and DC and go back 16 years or so and go to Louisiana? Well, in part because I don't want to offend anybody, and in part because the footnote to this particular opinion was so funny. Now, I do my best to tell some jokes as I give these presentations. As I'm sure you'll agree, as we continue, none of my jokes are funny. But maybe I can steal someone else's joke that happens to be funny. That's what I'm hoping to do here. Or at least as funny as an opinion can be, a court opinion. Anyway, we're talking about Culpepper and Carroll, PLLC, with which I am not personally familiar, versus Cole. Again, I'm not personally familiar, but this is a 2006 decision from the Supreme Court of Louisiana. And to summarize the facts oh so briefly, Attorney Culpepper was representing Cole under a contingency fee contract. Sounds like whoever this Attorney Culpepper is may be a good negotiator, because without even filing suit, Culpepper got what Culpepper considered to be fair dinkum. That's a British term? No, that's an Australian term. Whosever term it is, I intended to mean that he got a fair settlement offer. That was good, a good offer to accept in Attorney Culpepper's opinion. But alas, client Cole did not agree. So client Cole would not accept the settlement offer. You remember the rules of ethics. Ultimately, who gets to make the final decision as to whether or not to accept the settlement offer? Is it the attorney or is it the client? That's correct, it's the client. So although Culpepper may have tried the very best to convince Cole that it was fair dinkum, Cole and Culpepper went their separate ways. Maybe even Culpepper was terminated. All I know is Cole proceeded pro se in proper person without an attorney and tried to win and did not. Cole went away empty-handed, but Culpepper decided that Culpepper didn't want to, and Culpepper made the demand for a fee. Now, in adjudicating this, the question became, how much in fees does Culpepper get? And the part I love is the footnote to the opinion, where the appellate court agreed that the trial court was right to give Culpepper $0.00 on this particular claim. As Judge aptly observed, I'm quoting from the court opinion, 1/3 times 0 equals no contingency fee. His mathematic acumen is impeccable in this instance, which is another way of saying the trial court got it right. And I thought it was a humorous way of saying it. It's in the footnote to the opinion. But it helps me illustrate to you exactly what we're talking about when we talk about a contingent fee. We're talking about risk. We're talking about the possibility that you and I, fellow lawyers, will go away empty-handed with no money. That's what we talk about with a contingency fee. There's some parts of the contingency we may have some personal control over. We may be brilliant negotiators and be able to strike a good deal. Perhaps that might have been true for Attorney Culpepper. But regardless of how brilliant a negotiator you or I or he or she might be, ultimately the client may botch up the case for us. That's one of the risks we attorneys assume in no small part when we work on a contingency. So 1/3 times 0 equals no contingency fee, notes this appellate court in this decision. And that can be a reality if you choose to work on a contingency. Another reality, if you choose to work on a contingency, is the voluminous paperwork you're going to have to deal with. As mentioned earlier, at a bare minimum, your agreement for the contingency must be reduced to writing. You got to get it signed by the client. And in the majority of jurisdictions, you too must sign the written agreement. It must spell out certain details, such as what percentage is the contingency, if indeed it's a percentage. What do we multiply the percentage by in order to determine that number? For example, is it the gross amount of the recovery? Or is it the amount after costs are subtracted? When do I multiply by the percentage? Do I take the costs out first, then multiply? Or do I multiply and then take the costs out? These are the types of issues you see when it comes to the paperwork. Another issue very commonly you see, and you certainly see it here in one of my jurisdictions, the state of Florida, you see that clients have rights that the lawyer is obliged to share with the client when it comes to the client's rights about attorney fees. Specifically, Florida Bar Rule 4-1.5 has within it verbatim a lengthy and detailed statement of clients' rights for contingency fees. The rule is very specific. It says that before, so this is not to be done during or after representation, but before a client enters into a contingent fee contract for representation, the lawyer provides the client with a copy of the statement of client's rights, which is lengthy and detailed, and it's verbatim in the rules regulating the Florida Bar. That's not the end of it. It is the lawyer's obligation to give the client a full and complete opportunity to understand each of the rights set forth in the statement of client's rights for contingency fees. Does that mean that the lawyer who is about to work on a contingency for the potential new client has to get the potential new client another lawyer to represent the potential new client before that potential new client can hire the lawyer? No, that's not what it means. But it does mean if there's a communication breakdown or barrier, it's incumbent upon the lawyer who's about to sign up the potential new client on a contingency to overcome that communication barrier. Perhaps it's one of language. Perhaps you speak one language primarily and your client speaks another language primarily. You will have to watch out for language barriers. It could be a client under a disability. If you're doing personal injury cases and you're signing up the injured, watch out for injuries that might cause a problem in comprehension or understanding. And it need not be a mental health or a brain injury issue. There are a myriad of medications and treatments that an injured individual might need or drug they might be taking on advice of a physician that can interfere with cognitive abilities or the ability to understand. You've got to look out for these things and overcome them. And it's got to be done before the lawyer enters into the contingent fee contract. So you've got your work to do. You've got your work cut out, both in paperwork and in overcoming the potential for misunderstanding, because the rule regulating the Florida Bar 4-1.5 sub F says that it's incumbent upon the attorney to make sure to give the client a full and complete opportunity to understand each of the rights as set forth in the Statement of Client Rights for contingency fees. Also, who signs it under Florida Bar Rule 4-1.5? Is it the client? Is it the lawyer? Yes, yes. Both must sign it under Florida Rule 4-1.5. Who keeps it? Well, the client must be given a copy. Also, the lawyer must keep a copy. Where? The rule specifically, 4-1.5 sub F, says that you have to keep it in the client file. I know it can be tempting, and it may be even a better organization system to have one universal file keeping a copy of all Statement of Client Rights and all contingency contracts. You can do that for sure, but not exclusively. You've got to have a copy within the client file also. For how long must the lawyer keep the Statement of Client Rights for contingency fees? Under Rule 4-1.5, the length of time you've got to keep that initial paperwork that was signed at the beginning is the same number of years you've got to keep that final piece of paper, the closing statement. And that is not 1, not 2, not 3, not 4, not 5, but 6. 6 years you've got to hold on to the Statement of Client Rights for contingency fees. You're going to need it if the Florida Bar comes looking for it, whether that's because of a inquiry, investigation, or grievance of this particular case, or the particular ethics, grievance, or inquiry may have nothing to do with this particular case. It may have to do with the trust account. Invariably, if you're working on a contingency, that case is going to touch upon the trust account. You're going to need the trust account most likely most of the time. So when the trust account audit is done by the Florida Bar, they're also going to come looking for these documents, the closing statement and the Statement of Client Rights. So hold on to them. 6 years. 6 years can be a mighty long time, but that's specific in the rule. Now, with that said, what else is the paperwork requiring from us lawyers here in Florida? Also, the lawyer's contingency fee is set to a maximum. As I mentioned earlier, is this maximum set in stone invariably? You can never get around the maximum? The answer is almost yes, for the reasons I talked about earlier. It can't be a firm, definitive, never, never, never go beyond the maximum. But the rules carve out so narrow an exception for going beyond these maximums that we're going to talk about in the next several slides. So before those slides and before I get to those maximums, let's talk about that very narrow exception. To find it, we go to the official commentary to Florida Bar Rule 4-1.5. In the official commentary, it tells us that these maximums I'm about to go over in all these slides may, don't have to be, may be waived by the client upon approval by the appropriate judge. The waiver provision may not be used to authorize a lawyer to charge a client a fee that would be more than reasonable. So we can go beyond these maximums if the client wants to waive and that waiver is approved by the appropriate judge, and it doesn't add up to a fee that goes beyond reasonable. Now, the comments state the following. Note this sentence well. I will read it to you verbatim from the official comments to Rule 4-1.5 of the rules regulating the Florida Bar. You know I'm reading it to you verbatim because I put on my reading glasses. It is contemplated that this waiver provision will not be necessary except where the client wants to retain a particular lawyer. That's instance number one. Or, instance number two, the case involves complex, difficult, or novel questions of law or fact that would justify a contingent fee greater than the schedule, but not a contingent fee that would exceed Rule 4-1.5b. 4-1.5b says reasonable. So it can't exceed reasonable, even if you've got complexity, difficulty, novel questions of law. Still got to be reasonable. So that is where you can get around what I'm about to share with you in the next few slides, which are the maximum contingency that you can charge under the rules regulating the Florida bar. You'll note as I go through these slides, the maximum changes based on when the work ends, by which I mean it could be that you settled before filing suit, could be that you settled after filing suit but before an answer is filed or the time for filing an answer has expired. It could be that you settle after filing suit, after an answer has been filed, but after an answer where all defendants come forward, admit liability, and don't raise any affirmative defenses that require adjudication, so that the only thing to adjudicate is the amount of the damages. Or it could happen at post-judgment. Let's take a look specifically at what the rules say. A lawyer's contingency fee is computed as follows. Regardless of why the client loses the case, there is no fee for the lawyer, but costs are recoverable if the contract for hire says so. Lawyers, you have a choice. You can work for no fee if no recovery. You can work for no fee or no cost if no recovery. But make that choice, make it affirmatively, make it in writing, get the client's signature. But if the client wins the case, then the lawyer's fee is the percentage as stated in and as computed by the contract for hire, unless that contract is unethical. When's it unethical? I will answer that question for you in this presentation. Or if the client settles the case, I'm giving the client a lot of credit here, right? It's us lawyers that arrange the settlement. But remember, the client has to say yes. So that's why I phrase it this way. Or if the client settles the case, then the fee is the percentage as stated in and as computed by the contract for hire, unless, where's the rest of my unless? Unless that's unethical or unconscionable. When is that? That too is a question that I will answer for you in this presentation. So, what are the two questions I left unanswered from what I hope was an otherwise helpful slide? First, when is a contingency fee unethical? And second, when is a contingency fee unconscionable? Let's answer both questions. A contingency fee is unethical in Florida, in the majority of states, and under the ABA Model Rules of Professional Conduct, if the following requirements are not met. And I quote here from Florida Bar Rule 4-1.15 sub F. A contingent fee agreement shall be in writing and shall state the method by which the fee is to be determined, including the percentage or percentages that shall accrue to the lawyer in the event of settlement, trial, or appeal, litigation, and other expenses to be deducted from the recovery, and whether such expenses are to be conducted before or after the contingent fee is calculated. That is quoted from the relevant rule regulating the Florida Bar. Now, here's an important thing to remember. Even if the contract for hire meets these requirements, An unethical contingency fee arises when the fee charged exceeds the maximum allowed by that jurisdiction's rules of professional conduct. For example, the rules regulating the Florida bar contain the following maximums, which, if you're like most Florida lawyers, you just copy and paste into your contract for hire. You might even use the amount of the contingency fee that is already in the rules. It's up to you. No required maximums, but many lawyers simply copy and paste. Now, let's take a look at those maximums. First, what is the maximum before the filing of an answer or the demand for appointment of arbitrators? This is the same maximum that applies if no answer is filed or no demand for appointment of arbitrators is made, and the time for doing that expires. Either way, what's the maximum under that particular instance? 33 1/3. For the first 1 million of gross recovery, the 1 million gross is computed before deducting fees or costs or expenses. So if the gross recovery is 1 million or less, you're charging 33 1/3. What if it's more than 1 million? Well, you get 33 1/3 of the million, but the amount over a million, you get 30%. The 30% applies for the amount over 1 million up to 2 million. You settle for more than 2 million, then it's 20% of the portion of the recovery exceeding 2 million. And you can find these particular limits in Rule Regulating the Florida Bar 4-1.5. What if the recovery is made after the filing of an answer or the demand for appointment of arbitrators? That's what we just discussed. Nope. We just discussed before the filing of an answer. Now I want to talk about after. I got to read my own slides a little more carefully. Good thing they're on the big board where you can see them too. You're keeping me honest. I appreciate that. So a moment ago, we talked about before the answer. Now we talk about after the answer. And when we talk about after the answer, it's either the answer or the demand for appointment of arbitrators, either one. And it's either after that is done or the expiration of the time period provided for that to be done. It's either done or the time for doing it has expired. Either way, if that's when it resolves, here's your maximum contingent recovery under the rules regulating the Florida Bar, subject to that potential waiver of a maximum. 40% is the maximum of any recovery up to a gross amount of $1 million. Recover more than $1 million, you still get 40% of the first million, but the amount after $1 million, you get 30% of the amount you recovered between 1 million and 2 million. Recovered more than 2 million, you get 20% of the portion of recovery exceeding $2 million. That's the higher maximum if done after the filing of the answer. But that might not be true depending on what that answer says. Remember, as we mentioned earlier, there are those instances where every defendant comes forward in the answer and admits liability and does not assert an affirmative defense. And the only thing left to adjudicate based on that answer is the amount of damages to be awarded to your client. If all that's true, every defendant admits liability, no defendant asserts an affirmative defense, nothing to be adjudicated other than the amount of damages to be awarded to your client. If all that is true, then This is the new maximum. First, 33 1/3% of any recovery up to $1 million. You beat $1 million, 20% of the amount between $1 million and $2 million. You beat $2 million, then 15% of any portion of the recovery exceeding $2 million. And just like those other caps we talked about in those other two instances, in this third instance, you can find this cap in Rule Regulating the Florida Bar 4-1.5 sub F. Now, although those are maximums, there can be more added to those maximums. In addition to any one of those three instances of maximum percentages, a contingency fee contract in Florida may charge an additional 5% of any recovery after institution of any appellate proceedings filed or post-judgment relief or action is required for recovery on the judgment. This can prove helpful to a trial attorney. For example, in Florida, I am board certified in appellate practice, so I do quite a few appeals. I'm always flattered when a law firm, large or small, or a lawyer who's busy or not busy, turns to me to assist and to join as appellate counsel. Not all that long ago, a large firm, I won't mention their names, they're not for the powerful, they're for the people, was kind enough to get me involved in a case where I was able to serve as appellate counsel. The trial lawyer, in my humble opinion, as a board certified appellate counsel, should have never lost because that trial lawyer did an excellent job, a perfect job, wouldn't have changed a thing. In my opinion, the only problem was judicial error. Judges are humans. Humans make mistakes. That's what happened in this case. And thankfully, thanks to this rule you see here, I was able to join in at that late hour, be the lead appellate counsel, and not reduce my trial counsel's recovery. I had an appellate mediation. Thankfully, I was able to resolve the case at mediation. My trial counsel got the full contingent recovery, and I collected this additional 5%. Now, that means my referral source essentially didn't have to pay me anything. I like this particular rule for that reason. Also, don't forget this from Rule Regulating the Florida Bar 4-1.5F. It says that upon conclusion of a contingent fee matter, the lawyer shall, that's a mandatory, shall provide the client with a written statement stating the outcome of the matter, and if there is a recovery, showing the remittance to the client and the method of its determination. In the vernacular, we call this the closing statement or the settlement statement. As mentioned earlier, how long must the lawyer keep possession of this in the file? 6 years. For 6 years, you've got to hold on to that closing statement or settlement statement. Calculate it in writing, provide it, get the client to sign it, hold on to it for 6 years. 5 things you've got to do with this closing statement or settlement statement that you see described in Rule 4-1.5 sub F. This applies to a contingent fee matter. Paperwork. Contingency cases require a lot of paperwork. Can a lawyer work on a contingency on any and all matters? Can the lawyer have the freedom to contract with his or her potential client for contingency whenever the lawyer wants? Does the client have the freedom of contract to enter into contingency agreement whenever the client wants? As I stand here today talking, despite the fact that this sounds like an unconstitutional infringement upon the right to contract under the state constitution, it has not been found to be so. And the rules regulating the Florida Bar, like the rules of so many states, state that there are impermissible topics for contingency fees. Here in Florida, under Rule 4-1.5, again, subsection F, it's a long subsection. You should read it. It goes on for pages. A lawyer shall not enter into an agreement for, charge, or collect any fee which is contingent upon any one of the following types of cases. The first types of case, securing a divorce. So you can't work for contingency for someone whose marriage is not already dissolved if the contingency is the dissolution of that marriage. Securing a divorce, not a permissible topic for contingent agreement. Second, the amount of alimony or support. As I'll read to you from the model rules in a moment, this particular quote from Rule 4-1.5 of the Rules Regulating the Florida Bar has been interpreted narrowly by the official comment to Rule 4-1.5. For now, understand this: if there hasn't already been an adjudication of how much alimony or support, then you can't work on a contingency. More details to come. Number 3, property settlement in lieu of an amount of alimony or support in a family law matter. You can't do that kind of work on a contingency. Number 4, representing a defendant in a criminal case. I swear those words are on there. They're cut off. You see them? They're cut off. Am I responsible for cut off? I told you, I tell jokes. I warned you they weren't funny. They're cut off. Not my fault, right? Okay. But it says, if you can read it where it's cut off, it says representing a defendant in a criminal case. As mentioned earlier, can't do it anywhere, not even under the Rules Regulating the Florida Bar. Finally, remember, not long ago, the people of the state of Florida amended the Constitution of the state of Florida to provide for a minimum recovery to go to the injured plaintiff in a case of medical malpractice. This is an amendment to the Constitution of the state of Florida. But remember that Florida Bar Rule 4-1.15 and 4-1.15 allow a Floridian to waive his or her right found in the Constitution of the state of Florida to receive that minimum recovery in a medical malpractice case. Under the Constitution, the plaintiff victim of a medical malpractice is entitled to no less than 70% of the first $250,000 in recovery, plus no less than 90% of the recovery in excess of $250,000. But a waiver is permitted. How? The rules spell out exactly how your potential client can waive these constitutional rights. The rules even provide the verbatim forms that you can copy and paste and print and sign, and your client signs, and you take it and you get it approved by the appropriate authority. The paperwork's right there in the Rules Regulating the Florida Bar. Keep in mind, this only applies to medical malpractice cases. The statutes will tell you whether or not the particular case sounds in medical malpractice. If it is med mal, then you're either taking no more than this cap, or your client might waive and the waiver might get approved. What if you run afoul of any of these rules? That obviously can be a problem that can subject you to discipline. But in addition, it can result in either your fee becoming uncollectible, or if you've already collected it, it can result in the fee being clawed back, taken back from you post-collection. Unethical contingency fees cannot be collected because unethical fee agreements cannot be enforced. Florida Bar Rule 4-1.5D and the Supreme Court of the State of Florida's case law interpreting that rule say that any fee earned through a violation of the rules regulating the Florida Bar is a fee that is forfeited by the offending lawyers. And I do mean when I say any violation of the rules regulating the Florida Bar. What if it's a solicitation violation? The client was improperly solicited by the lawyer. Loss of fee, forfeiture. What if it's an advertising violation? What if the client was obtained in whole or in part due to an advertisement that was in violation of a rule regulating the Florida Bar? Forfeiture by the Florida lawyer. What if during the course of representation a conflict of interest arises and it is not remedied to the extent that the fee arises out of the violation of the conflict of interest rules? Forfeiture by the Florida lawyer. What if the fee fails the test for reasonableness? Difficult to fail that test, but at least in theory, that's a light snap there. Forfeiture by the Florida lawyer. What if this paperwork is not in order? Wow, that's extreme. And as your friendly neighborhood bar grievance defense attorney, I gotta admit, I haven't seen the case where a forfeiture was awarded because of that. But certainly, there's a risk of forfeiture in such an instance. So dot your I's, cross your T's, get your paperwork right. If you're doing a volume practice, get some help. Train your help. Train those paralegals, legal assistants, clerks, case managers, field officers, investigators, and any and everyone else under your command. So you don't have these things that can lead to, here comes the snap, you ready? You ready? Forfeiture of your fee under the rules regulating the Florida. I warned you my jokes weren't funny. I'm doing the best I can here, people. It's ethics. How funny can it be? Cut me a break. Okay, all right. So it's not a matter of how much of the fee is lost. It's a loss of the entire fee. All of the fee is lost. Fees traceable to a rule violation, those are fees you can't collect under the rules regulating the Florida Bar. That's true for any and all fees, not just contingent fees. I know the focus of this first unit has been contingent fees, but don't misinterpret these forfeiture rules to apply only to contingent fees. They apply to any fee, hourly fee, flat fee, non-refundable fee. You name the fee. Forfeiture, if obtained through a violation of the rules regulating the Florida Bar. This is so important that I'm driving it home. I hope I'm driving it home. So take note. Now that answers the first of the two unanswered questions. Can you remember that far back? I had a nice slide with two unanswered questions on it. The first unanswered question was, when is a contingency fee unethical? But there was a second unanswered question in those slides. The second question was, when is a contingency fee unconscionable? Now you, my friend, may be an expert in contract law. And if you are, you'll probably tell me that the unconscionability of a contract, if it exists, can lead to the avoidance of the responsibilities owed under that contract. But you'll probably also tell me that unconscionability is a difficult thing to prove and that instances of unconscionability are few and far between. That's the same law that applies here. Unconscionable contingency fees don't arise every day. It's not a common occurrence, and it's not a common reason for making the fee uncollectible. I can tell you, however, that unconscionable contingency fees do arise in two circumstances, both involving insurance. One is a claim for life insurance that is not contested. The other is a claim for first-party insurance where the insurer tenders its policy limits. First party, what does that mean? What is first-party insurance? What do I mean when I say first-party insurance? First-party insurance is a policy that pays the policy holder for a loss suffered by the policy holder. So it's your own insurer where you bought the policy, you're the one entitled to payment, and you're asking the insurer that you were paying the premiums to now cough up and write you a check. That's first party, a first party claim in insurance law. Another phrase I used a moment ago was when the insurer tenders its policy limits. Tenders its policy limits. What am I talking about? With few and far between exceptions, insurance policies contain a limit, a maximum amount that the insurance company has to pay for certain liabilities, such as damages. That's called the policy limits. There are times where the insurer wants to avoid litigation, wants to avoid a duty to defend, wants to avoid hiring a lawyer to defend its insured, or for similar reasons may decide to just cough up all the money, the maximum amount, the full limits. We call this a tender of the policy limits. An insurer tenders its policy limits when it voluntarily pays out the maximum amount payable under the policy rather than opposing the claim made under the policy. Now, McGinley, why are we suddenly studying insurance? Because unconscionability of an attorney fee from an ethics point of view is so rare, so few and far between, that I've got to enter the realm of insurance law in order to find you an example or two. It's the rare scenario when a contingency fee is unconscionable. The standard for unconscionable in the context of contingency fees is so forgiving that it is difficult to fathom a scenario where that standard is met. It is almost safe to say that any contingency fee at or lower than the max allowed by rule is conscionable, other than a claim for one, life insurance that's not contested, or two, first-party insurance where the insurer tenders policy limits. Is that a firm statement from me that that's the only two instances of unconscionability? No. Look at all the wiggle language I got in there, people. Lots of wiggle language. But as I prepare to explain when it's unconscionable, the definition is vague. Examples help, and examples are hard to find. The fact that examples are hard to find helps to illustrate the difficulty in pointing to and proving that a particular attorney's fee is unconscionable. So the issue is there, the possibility is there. You may never encounter it in the real world. It certainly exists in theory. Here's two real-world examples: life insurance that is not contested, first-party insurance where the insurer tenders the policy limits. So, to summarize, how is a lawyer's contingency fee computed? It's computed A, B, or C. And I didn't cut off C this time. I did better this time. It's computed A, B, or C. A, regardless of why the client loses the case, and you remember that Culpepper case from Louisiana, right? It wasn't Attorney Culpepper's fault that the client didn't recover. So Culpepper came forward looking for a fee, but it was contingent, held the court. And a percentage of 0 equals 0. Regardless of why the client loses the case, there is no fee for the lawyer. What about costs? Maybe, maybe not. Costs are recoverable if the contract for hire says so. That's A. Remember B. Congratulations on your victory under B. But if the client wins the case, then the lawyer's fee is what? It's the percentage as stated in and as computed by the contract for hire. Remember, you and the potential client, before the potential client became a client, negotiated, calculated, put in writing, and both signed. That's how you do the math afterward, based on that writing. So if the client wins the case, then the lawyer's fee is the percentage as stated in and as computed by the contract for hire. When's the only time that isn't true? If the contract is unethical. Letter C. Or if the client settles the case, that's the instance here under letter C. If the client settles the case, then the fee is the percentage as stated in and as computed by the contract for hire, unless the contract is unethical or unconscionable. There's a myriad of ways it could be unethical. And there are a rare few ways where it could be unconscionable. Either one, unethical or unconscionable, then this letter C would not apply. So there you have it, my friends, the first unit in our discussion of the ethics of attorney fees. This unit, as promised, focused primarily upon all the issues that arise when a fee is on a contingency. But ethics and attorney fees involves far more than just contingency fees. Any type of fee is subject to some very strict and demanding rules of ethics. So stay with me and watch the next part where we will discuss the ethics and attorney fees as they apply to fees that are not contingent, or for those of you who only work on a contingency, don't leave me now. What if the fee is part contingent and part not contingent? What are the rules then? I'll also cover that in our next unit. Until you watch that one, may God continue to bless us all. I'll see you in the next unit. Thanks for joining me. Trying to make a graceful exit. How's it going? Is that graceful? I don't know. Someone who crawls. Is that an act of grace? I don't know.